I'm David Levine. I'm co-chairman of Science Writers in New York and one of the organizers of this event. I'm here to introduce Doug Levy, who's I asked to come in and he lives in San Francisco now, and he said he'd come, so which is very nice. Doug is a science writer based in San Francisco. He has been focusing on the intersection between science and journalism for more than 20 years. He was a health reporter for USA Today. He's going to talk about many things, but the name of the panel is Getting and Protecting Information, and we're going to talk about Freedom of Information Act. He was a public records point person at the University of California, San Francisco School of Medicine, where he was Director of Communications from 2004 to 2009. He was also became Chief Communications Officer at Columbia University Medical Center from 2010 to 2015. Doug holds a law degree from the University of Maryland and a journalism degree from the Northwestern University. So I thought he'd be the perfect person to moderate this panel, which talks about legal implications of being a journalist and protecting your information. We also have a computer specialist. So Doug, I'm going to turn it over to you.
Thank you.
Okay.
Thank you, David, and thank you all for being here. This is a topic near and dear to me. As David indicated, I've been on both sides of public records, both as the reporter trying to get them loose and sometimes being on the other end of those requests, trying to help reporters figure out what's going on and how can they best tell their stories. Because as a public information officer, I saw my role as helping reporters do their jobs, not being an obstacle. The truth is not every PIO sees their job that way. That's a whole other topic, but I'm also delighted that I'm on the journalism side of things again, which is really where I'm more comfortable. So I'm delighted to be here. I have a little bit of deja vu because about 20 years ago, I was giving a series of talks in Budapest where a group of us were training health and science reporters from the former Soviet states on how to deal with this new freedom that they were experiencing. You know, if you've grown up in an environment where information was not free, and now all of a sudden it is, that's a big change. And how do you figure out what's news? How do you figure out what's a story? How do you know if the information that you've got is real? These are all questions that most journalists are dealing with every day. And as the previous speakers talked about, things have gotten a bit more complicated, but there's also lots of new opportunity for journalists in this era, which is a good thing. Our panel is here to talk about some of the practical realities of both getting information and protecting it, protecting the information, protecting your sources. How do you deal with making sure that the flow of information, whether it's from government or other sources, is solid and secure? My hope is that when we're leaving this room, we're going to have some really practical knowledge that we can use to make our reporting better. Because access to information is fundamentally, that's the main tool that journalists need in order to do their jobs right, and to make sure that we're not just being the stenographers, to verify that the information that the government office just published is true. Sometimes it is, and sometimes it isn't, and that's not a partisan thing. That goes back to the beginning of time. We will talk some about the laws that underpin the concept. You'll hear a lot of talk about FOIA, the Freedom of Information Act. But I also want to make sure that we don't mistake the existence of that law for the rights that are fundamentally in our Constitution. The Freedom of Information Act provides some mechanisms to access information. But public information is public information, fundamentally. And that's a concept that we need to make sure that we keep in mind at all times. The fundamental principle is that the public's business belongs to the public. FOIA and other laws help us get that information, but it's not the only way. Our job is to hold public officials accountable for what they do, whether they're scientists or agency officials or just everyday workers. And some of the best stories that we've seen in all fields, including science, have to do with data or other information that came through FOIA. So I am delighted to have a great panel. We have 4 different people who have different approaches to FOIA and the access to information and how we handle it as journalists. So I think we're going to have a lot of really good information. From left to right, right to left for the audience. Directionally challenged, which is really fun driving in California. We'll begin with Matt Schaefer, who's counsel at BuzzFeed News. Matt is an attorney at BuzzFeed, which of course is a multi-platform global network for news and entertainment. He is the newsroom lawyer, the newsroom counsel for their US bureaus. And a big part of what he does is he helps protect journalists, or at least be aware of their liability when they're reporting stories. In addition to his law degree, Matt has a master's degree from Louisiana State University in mass communications, where his thesis focused on the First Amendment issues that are involved when subpoenas are filed against reporters trying to get them to disclose confidential sources, which is a very important topic. Next, we have Ben Schiller, who is a staff writer and editor for Fast Company. He is a reporter who has been, one of the many trying to free up that information so that we can tell better stories. Ben is with Fast Company. He's previously edited a European management magazine, and he's been a reporter in 3 very different environments: San Francisco, Prague, and Brussels. So different perspectives, which is helpful. To his right or left is Charles Seif, who's a journalist and a professor from New York University. Before joining the Department of Journalism at NYU, Charles was a writer for Science magazine, where he specialized in physics and math. He also had been a US correspondent for New Scientist. His work has appeared in The Economist, Scientific American, the Philadelphia Inquirer, the Washington Post, the New York Times, and many other publications. And on the other end of the table, whichever direction you're at, Susanna Schmelk, who is an independent security expert. She is a senior security analyst for one of the major hospitals in the area that gives her a lot of practical experience on information security. She is also a doctoral student at Pace University. She was named one of the top 5 influential IT security thinkers of the year in 2011 by a trade magazine in her field. And her degrees, she's got more degrees than probably anybody else in the room, which is impressive, because there's a lot of people with advanced degrees in the room, I can see. She, in addition to her doctorate, she's got 2 master's degrees, one in computer science and technology management, and also in cybersecurity. And I'm very pleased to have this wonderful panel. We're going to take questions kind of as they come up, so we're going to be talking, among the panelists. But if you've got a question, please, don't hesitate to step up to the mic, and we'll work you into the mix. Thank you all for being here. I'd like to start with Charles. Can you talk a little bit about the role of this concept of freedom of information in the day-to-day workings of a reporter who's trying to get the real news?
Well, for me, the role of a journalist, and you've heard the cliche of where our job is to comfort the afflicted and afflict the comfortable. There's nothing that afflicts someone who's comfortable more than actually getting their lies called out. Verifying what people with power and authority say to make sure that they're actually telling the truth is an important role of what we do. And we journalists have a panoply of tools to do that. I mean, interviews, we speak to people, we examine data, we examine documents. Turns out that FOIA is one of the most powerful tools that we have in our armamentarium for looking at a certain portion of the federal government. That it is not a panacea, it is not it doesn't reach into much of what we want to look at, but it allows us to make the government disclose documents that we think are in the public record, that are produced on behalf of the public. And from a working journalist point of view, it kind of fills a certain niche that other sources won't necessarily be able to fill. When you're trying to look at the inner workings of an executive branch agency and seeing whether they are following the law or whether they are performing what they say they are performing, unless you have a leak or an insider or some very good people who are willing to go against their bosses, no one is going to tell you, yeah, you know, we're breaking the law most of the time. So FOIA, for me, allows me, when I have a suspicion that a government agency is doing something wrong, gives me hopefully a very precise tool for seeing whether or not that is happening. Whether the public statements that the agency is making, that we are doing our job, we're following the law, we're working in the interest of you, the taxpayer, verifying whether that's correct and whether they're in fact doing their job properly.
That's really the key. It's part of the accountability process. And I have found that sometimes the mere request for information, in some cases, is sufficient to prompt an agency to stop misdeeds. In one case, I FOIA'd some records that I knew existed. I didn't have access to them, but I knew that the agency responsible had access to them but wasn't trying to get them. By filing a FOIA, that forced them to acquire those records and see, oh my God, that public official is spending the money wrong. And it made a better story, but more importantly, you know, for the public good, it actually stopped misconduct in office. That's kind of a good thing. Ben, you've done a lot of investigative reporting, and sometimes FOIA is important, sometimes not. What are the impacts in your work of this concept?
Well, I think first of all, you have to assume that everyone's going to lie to you all the time, and if they're not going to lie to you, then they're at least going to shade the truth. And I think because we're dealing with people's careers, we're dealing with money, we're dealing with whether they get established as entrepreneurs or public figures and so on. So you have to accept your role as a journalist is powerful, and not to let it go to your head, but people are going to shade the truth. So I think you have to question people's first principles when they're talking to you. You can't assume that anything they say is accurate, and I think you have to proceed from there with a sort of.
Which comes first, the interviews and polite requests or the FOIA request?
I think you have to be polite to begin with, and then sort of go down from there. You know.
Charles, what do you think on that?
Well, it depends on the circumstances. It depends on the story you're writing. For example, when journalists are told to, if your mother says she loves you, check it out. I mean, people do lie. And it may just be something that allows you to verify a very small piece of someone's story, which is incidental, asking them politely to turn over that piece. They'll probably will do it, and it won't be a problem. If you have a suspicion of a systemic issue, and I actually save the interviews with the probable malefactors for last. I try to get all of my ducks in a row so that I can have the most powerful interview that I can, and part of doing that is gathering the documentary information first. You should be aware that generally if you do a FOIA, sometimes, most of the time it happens that the people involved will know that the FOIA occurs, that the people you are targeting will have a sense of it, so it's not like you have a secret there. But if you prepare them in advance for a FOIA and let them know what you're seeking, it may sometimes help them avoid telling you what you want to know.
I think
Matt,
just to pick up
I'm
on
sorry.
something,
Yes,
so I
Ben.
think there's nothing worse than going to your ultimate target first of all and sort of blowing the interview because you didn't have that didn't have the right question to ask. So it's definitely good to keep that till last.
This is a great panel. Could you give specific examples?
Certainly. Of a FOIA request which yielded wrongdoing. For example, a number of years ago, I was looking at, this was actually a database story, the Dollars for Docs database. And if you aren't familiar with the Dollars for Docs database, you should all become aware of it. The ProPublica compiled a list of payments which were disclosed from drug companies to physicians. And it occurred to me that most research scientists, clinical research scientists, or a good proportion of them are physicians as well. So I decided to join Dollars for Docs database with the NIH grants database and see who was getting money to study certain things and whether they were actually disclosing that information as required by law on their grants. And so I ran this join, and lo and behold, there were lots of NIH scientists getting lots of money from drug company, lots of NIH grantees getting money from drug companies, which isn't itself bad. But then the question is, were they following the law and telling the committees that they were getting this drug money? And so I FOIA'd the grant application where they have a little checkbox. I have a conflict of interest or I have no conflict of interest. And the physicians that I interviewed swore up and down they had no conflict of interest. They told everyone. I had a documentary bit of information saying, no, you're lying, this is wrong. And I was able to pin them because of really just that checkbox that they didn't do.
We're going to go to a question from David, and then I've got a question for Matt. But David, please.
Yeah, David Levine, quick question. I had a FOIA turned down. No, they did not give any reason, and but I think people should be aware. Not every FOIA is honored.
Well, part of the issue there, and something which I hope conferences like this will help with, is there is a vast misunderstanding about what's required under the law. I will never forget a meeting I was in, I won't name where it was, but you could probably figure it out, where I thought the meeting was to figure out how we were going to respond to this batch of FOIA requests that came in. And the general counsel, one of the other public affairs officers was there, I was there, a bunch of lawyers. And the person who called the meeting started off saying, okay, we need to figure out how we can get these to stop. And the good thing was that the lawyers and the public affairs folks kind of all in unison said, that's not how it works. And we spent the next half hour explaining to that senior official that by definition, his work was public. And that's the way it is. But you have to sometimes educate people. When a FOIA request is turned down flat, that's relatively rare. Usually they just drag them out. But that's when you probably do need to bring in the legal guns. And actually, let me turn to our legal gun on the panel, Matt. Matt, when do you shift gears from the polite request to the legal action? And also, as we approach big stories, at what stage should that FOIA request happen based on what you've seen works?
So at least as to the second question first, the FOIA request should just go in as soon as possible. Depending on the agency, you're looking at anywhere from 3 months in the best case scenario, probably. It's not to say that some people don't actually get it within 20 days, which is what the statute requires. But you're looking at 3 months to anywhere to 3 to 5 years to get these records. So that's just, unfortunately, that's just the state of affairs right now. I always tell people that FOIA officers are people too. So I try not to antagonize them too much when it comes to these things. These are folks who are very busy. Usually their offices are underfunded and understaffed. So really, I try to become best friends with FOIA officers. Bernice in Washington, D.C., for example, she just got a new house. So really, I mean, you know, it just, seriously, Bernice did get a new house. It was late on the closing, but she's moved in. But really, it just depends. You just kind of have to, you know, bring some common sense to the table. And if you think you're getting the runaround, you probably are. And at that point, that's when you start actually, you know, citing statutes at them. A great tip that anyone can do, I think, and that's usually pretty effective, FOIA requires an agency to respond to you with an estimated date of completion. So anytime you think, well, shoot, this FOIA has been outstanding for 6 months, it doesn't seem like it's that complicated of a request, I would email the FOIA officer. You can just Google 5 USC 552, which is FOIA, and you can look for that estimated date of response clause in FOIA, quote that at them and say you have a statutory obligation under FOIA to give me an estimated date of completion. It's usually a good way to at least get an answer out of folks.
And every once in a while, there's a legitimate reason for the delay. Unfortunately, that's probably increasingly less the case. But in quite a few cases that I've seen, both requests that I've made and requests that I've been involved in responding to, the reporter was asking for something that in some cases didn't exist. But if the FOIA officer is helpful, you can be guided to the right questions and then get the right answers. I remember one time I was working on an FDA story, and I actually wound up sitting in the office of the person on the other end of my request as he was on the phone with the Office of Management and Budget trying to figure out what records could they give me. And it turned out there was a very legitimate reason why the specific information I was asking for could not be released to me. But what they did was they figured out what they could that effectively gave me the information I needed, just not quite as neatly. That was legitimate. Let's hope that happens less frequently. I mean, I would like Freedom of Information Act requests to get complied with promptly, simply. Please come to the microphone if you've got a question. Matt, how do you shape those big requests in a way that makes them manageable both legally and practically?
Sure. So, I mean, a lot of times, because reporters necessarily want information, you'll see requests that say, I would like any and all records relating to Hillary Clinton from 2001 to 2016. Thank you. It's not a great request. Really, I mean, I think the key to shaking big requests loose are to divide them out into smaller bite-sized portions by topic and by time. Do those requests sequentially. Sometimes agencies will catch on to you and be like, we realize that you asked for every email about Hillary Clinton from 2000 to 2016 in 500 separate requests. We're gonna bundle those together and you're gonna wait forever. But like, as a practical matter, it does help to just try to have some conservative leaning when you make that request. It's a balance. I understand that you never want to leave a document in an agency file cabinet, but really with understanding the pragmatic way that FOIA operates right now, which is a money and a personnel issue, it's really, really important to try to rein in what you are asking for in the first case. So you're not waiting for 2 years and then it's old news at that point.
And might I add that the better you know the agency you're targeting, the more narrow and specific your request can be. So spend the time to figure out what the directorates are and what the offices are and who the personnel are that you are probably going to be discussing the documents that you want. And that way you can really narrow a large request to a portion of an agency or a time period. All sorts of ways of narrowing it, make it go faster, make it easier to retrieve, and make it less likely that you'll be stuck for 7 years with no documents at the end of it.
And that kind of due diligence also sometimes points you to other sources for the same data, which is really where it gets fun. I'm going to come to Susanna in just a moment, asking about how we keep that information secure as we're handling it. Let's take your question, please.
You guys actually pretty much answered the question, but my initial question was, can you give us some tips on how to make better FOIA requests? In the case that you guys illustrated with knowing the agency better as one tip, but what if you're sort of sifting through ideas, or you would like to try to secure information from a particular agency, but you don't know how to file the FOIA, because it's very important to be specific, to ask the right question in order to get the right information back. And also for the audience, there's a website that I've been using as a tool for FOIA, which is called Muckrock. I'm not sure if you guys are familiar with it, but it's a really excellent tool to help process and to help manage the process of filing a FOIA request. And when we get a kickback from the agency, it normally tells you why it hasn't been filled. But sometimes, as a journalist, you're not exactly sure. And so can we just have a few tips before you move to the next topic? I think at least it's related.
Certainly. I'm going to jump in real fast on this, because in addition to understanding the agency and the structure there, you should have as much of an understanding of the laws that dictate that agency's work. Because in some cases, you'll find a nuance in the law that allows them to keep certain things confidential, even if logically it should be public under FOIA. But more importantly, it gives you a better idea of what information may be out there and who might have it and who's allowed to share it and so on and so forth. The other thing, if you're covering things beyond the federal government, many states have their own versions of public records laws. And in some cases, information that you're trying to get from the federal government may also be available from other government entities. And that's sometimes a better way, sometimes not, but the more you know about that framework, the more successful you're going to be at navigating it. Any other specific tips?
What did you mean by nuance?
Well, so for example, there are some statutes that give an agency access to business confidential information as part of their regulatory oversight. And as part of that oversight capability, they are required to keep certain details from public release. You'll see that with EPA, USDA, and FDA in particular. We could debate whether those exclusions should be there or not. That's a separate thing. But if there's a statute that says the drug companies are required to give the FDA access to this set of data, but that is to be treated as confidential, that's the law.
And building upon that, it's no government agency can do anything without a law that authorizes it to do what it's doing, and then regulations which give more detail about how they should be doing what they're doing. So if you're in the process of looking at the agency, look at the regulations for the process that you're interested in. Like I was interested in waivers for government meetings, and so 18 USC 208 was the law, and then each agency had a regulation stemming from that law. And from looking at that regulation, I saw that, okay, every time they have a certain waiver, they have to communicate with the Office of Government Ethics. And communicate with the Office of Government Ethics, those are documents. So by looking at how the agency does its work as required by regulations, it will sometimes lead you to processes or documents that you can tap with a FOIA to get more information.
We'll come to the audience in a moment, but and Susanna, I'm going to come back to you in just a second, but I want to ask Ben one more question on this. Have you noticed any change in the attitude among especially government sources in the past couple of years?
Oh, absolutely. I mean, I worked in a few different places, and I think in Europe, if you call up a government department and want to talk about climate change or some of these firm scientific controversies, there's much less pushback than there would be here. I mean, I think everything is so contested these days. It's basic questions.
So that leads to the issue of when you've got a confidential source, how do you keep them safe? And how do you keep information that you're getting from those people safe? Susanna, can you talk a little bit about the practical reality of data security for journalists?
Sure, definitely. So, data security, it's not binary, like it's safe or not safe. It turns out there's a lot of risk involved in things. And so you really want to categorize, what's the impact if this is exposed? Is it my story that is leaking before I want it to be leaked? What's the impact of that? And also the likelihood, how likely is it that if I put my thing up on a website that's unprotected, that somebody will read it and actually use it. So a lot of times you analyze your cybersecurity and from a risk perspective. So, and taking that knowledge, you actually look at the confidentiality, integrity, and availability of the data. That's kind of the typical way of looking at your data and keeping it. Either confidentiality is making sure that only certain people have access and read it, and integrity is making sure that somebody hasn't changed it on you, and availability is making sure that it's available when you want it. And then given those three pillars, you actually then can look at systems in reality. And there's usually about, again, 3 different ways to look at systems. You look at their physical security. Is my PC sitting in the middle of the street? That's probably not too safe. And then you look at the technical security, and so that's actually how the companies and how the management has implemented the technical side of things. And then you also look at the administrative side of your data. And so if it's being managed by another party, the administrative, is that party getting security training? Is that party, having some sort of access control? And so from us, a lot of times we have to trust, third parties for our data. And so you really have to think about it from that perspective, that there is a lot to it. It's not such a binary, it's secure or not secure, that there's very broad backgrounds on how these systems are being developed. It's very eclectic space out there. So it's a very difficult and challenging problem that requires continual upkeep and continual work, because a reconfiguration of your server, can completely change the risk of it. So it's not like you can just shut the door on it and walk away. It requires continual maintenance.
And as you look for alternate sources for that data and those documents, you need to make sure that if you're promising confidentiality, you can actually deliver on it. We'll be talking a lot about that. Yes, please.
Hi there, Michael Halpern with the Union of Concerned Scientists. FOIA works really well when stuff is written down, but I remember during the Obama administration, I would talk to scientists who were hand-walked over edits to documents rather than making the edits and sending them to the scientist. And now that has escalated quite a bit. There are a lot of reports that I've had and have been reported publicly of people being told not to take notes in meetings, of an administrative record not being created in the first place. And so I'm curious what you think journalism societies and journalists can do to create more space for that record to be created, either empowering civil servants or pushing government to do better or allow that kind of activity, or what's the solution there? How do we actually make sure that accountability can happen in that way?
Who wants to take that?
I can't believe some of the things that are written in emails. But I think you're right. There is going to be that institutional push to not write things down, and FOIA applies to records held by the government. Certain retention policies are issued by NARA, the National Archives. But we can't really, I don't really know what we would do to kind of force their hand, I guess, in memorializing this stuff more than not, because certainly if I was sitting in an agency, I would say, pick up the phone, and there's just not a lot that I think we can really do in that regard. It gets to like the inherent problem in transparency that I think we think about a lot, which is the more transparent the government agencies have to be, the more secretive they're going to try to be. And it's just kind of the natural balance of things, and sometimes it swings in one direction and sometimes it swings in the other direction.
And transparency has costs. I mean, it has monetary costs as well as these emotional costs upon the process of doing government. It's harder to work when people are looking over your shoulder. The FOIA statute, as well as most of the state FOIA statutes, try to create some of that balance within the wording of the law. FOIA has a privilege, a deliberative process privilege, Exemption 5, which is supposed to prevent exactly some of the problems that Mr. Halpern was talking about. That the deliberative process privilege protects discussions surrounding policymaking, so that you're able to give frank advice within government and not feel that you're in this fishbowl. There's a provision for private information to protect the personal privacy of people. There's a provision to protect confidential commercial information. So there are little bits and pieces that shield portions of that information from disclosure that are meant to make government function better and not suffer too much from this transparency problem. However, in practice, often we will see that those privileges are extended way beyond where they should be extended. Exemption 5 in particular is basically a catch-all. We don't want to disclose, therefore we won't exemption.
It's very similar to what we see with HIPAA. HIPAA is the federal privacy law that protects health information. And how many of you have made a request to a medical center and been turned down because of HIPAA? In most cases, that's not really under HIPAA that gives the authority to turn down the request. It's that the people who are responsible for responding may not have enough understanding of what the law and the regulations actually say. And it's really easy to say, we can't do that because of this law. And that's where the more that we as journalists understand the ins and outs, the more we're able to have an intelligent conversation with those administrators and hopefully get through it. Yes, please.
Possibly I'm the only employee of the federal government here. Am I? Yes, okay.
Welcome.
In which case I shall be totally anonymous. Let me answer your question first. Should anybody in a politically appointed role ask a career civil servant to not record something? One of the most important things to do is, of course, to follow up in an email, writing down all the things that they told you not to say, just to confirm that they understood properly what it was. And, of course, that creates a document which, of course, can be requested. And should I have been a director of a federal government lab, I might well have advised my people to do such a thing. But obviously not in writing. There's one element that all of you guys, of course, you're all legitimate, asking for legitimate information and things, but you're missing out on what actually happens to most of the federal FOIA offices that are working on controversial issues, is that they are targeted for political reasons, and people use FOIA and FOIA requests as a political weapon. And I'm sure none of you have ever done that, but it happens. And so part of the response from the federal government and from people who are kind of on the ground, scientists and people who are working, is it is coloured by that. I mean, we were FOIA'd by a lobby group who had this totally ridiculous notion about how things worked, And of course, there was nothing to respond to because they had a totally erroneous theory of what was going on. Then they put in a FOIA request to see what the responses to the FOIA request had been, because they thought that there'd been this whole big conspiracy about the FOIA request that had first come in, but they hadn't really factored in how long it takes us to respond to these things, and so there was nothing there either. And so when there was nothing coming back on both of their requests, they sued us. And it took 5 years before that lawsuit was dismissed with prejudice. And that's an enormous amount of effort and money and time and stress on the people who are being targeted. And while the statutes and the case law on FOIA are excellent, and you mentioned some of those exemptions, is still this pressure and this politicization of the process that is directed at, scientists who speak in public, or that's directed at research programs that are politically inconvenient. And you can't ignore that that's also part of this landscape that currently exists.
One of the, actually, as Mr. Halperin had mentioned in the earlier panel, that there is this practice of using FOIA as a denial of service attack, and I think we've all seen that. And as journalists, how can we help distinguish what we're looking for from the activists who are trying to do something different?
I mean, this is a very good point, and there are climate change comes as one of the hot button issues where you have nonprofits or individuals on one side flooding agencies with vexatious FOIAs, and it is a problem. However, I am very frightened about weakening or altering FOIA to defend against such vexatious FOIAs, because it's really hard to define what vexatious is. And if you look to, say, England, where their equivalent of FOIA has a ability to block out vexatious Freedom of Information Act requests, that clause has been used, for example, to prevent queries of police misconduct by credentialed journalists. So the law, I mean, this is true of all laws. All laws have bad effects as well as good effects. And it's often extraordinarily difficult to refine a law so that it is, you enhance the good effects without increasing the bad effects. I mean, even just look at the First Amendment. We all think, I mean, our profession is built upon freedom of speech. And things like Charlottesville are a direct consequence of our discussion about what it means to have freedom of speech. Does this mean that hate speech is protected? How can we block speech that is damaging without damaging that fundamental right? And I would put FOIA on a similar plane, that there have been calls for adding additional exemptions for scientific process privilege or something like that. I'm just afraid that that will put the balance in the wrong direction. So while I acknowledge that this is a problem, I'm afraid that any of the fixes would be worse than the problem itself.
Matt, one of the things that we've seen agencies do in response to those, well, actually in some cases to legitimate responses, but to the other ones too, is to say, oh, we'll get you this information, but it's going to cost you. How has that factored into the whole mix, and what do you do?
So, I mean, luckily, when it comes to journalists requesting records through FOIA, there are fee categories. Normally, FOIA allows an agency to charge for search, duplication, and review fees. But if you're a member or representative of the news media, you get to say, hey, here's my publication history. I plan to disclose the information I learned to the public. You should put me into this fee category. And then they can only charge you for duplication fees, which is basically nothing nowadays. So really, if you're making a request as a journalist, it shouldn't cause you too much problems. But that's not to say that there aren't the kind of fun outliers where you see, the Department of Army assess FOIA fees for $793,000, 800, it's just, you do have those. But really, the law is pretty good. If you're a representative of the news media, you will get a waiver on fees. Also, you can always make an argument in a FOIA request that the records that you're requesting are in the public interest, and you do intend on disclosing those records in some form or another, and therefore the agency should waive all fees. So usually if you put forward both of those things, hey, I'm a journalist and this is in the public interest, fees should not be too much of an issue.
I come at the FOIA question from having lived on both sides. I was a reporter for 20 plus years. I used FOIA and got very frustrated by government officials stymieing my efforts sometimes. And then I just came off of 8 years in the government where my job was to be careful about what we released to journalists. And I have one bit of advice and one question. The bit of advice for reporters is it is very helpful to work with a FOIA officer to narrow your request to a reasonable degree. If you don't really know what you're looking for and you're on a big, broad fishing expedition, it's not going to go very well and it's going to take too long and you're not going to get what you want. But most FOIA officers, at least in the administration I was in, were pretty willing to sit down with the reporter and figure out what are you really looking for, and let's figure out a way for you to get what you want without me having to spend the next 9 months sifting through 1 million documents to find what you need. So it's worth actually having that conversation and trying to be positive about it. The thing I lived in fear of as a Fed was someone coming at me with a FOIA request that said, please send me all emails that have either WTF or OMG in the subject line, which I thought would be a great way of getting an enriched sample of whatever's going wrong in that agency at the time. So my question is, would that be considered a legitimate FOIA request, or was I living in fear for nothing?
I think that's a legitimate request.
Yeah, and in California, if that was a request to a California state agency, it would unquestionably be legitimate. I'm not sure how much discretion would be in the federal law, but in California, all government records are public unless they meet one of a very small number of very specific exclusions. So, my phone record was public, and that's just the way it is.
And I think in all seriousness, though, all FOIA requires is that you reasonably describe the records. I think that if someone made that request, that's a reasonable description of exactly what they want. I think that's...
Yeah. Now, that's when the practical side comes in, though, and as the person who asked the question pointed out, in some cases, reporters have this idea that there's this really organized system of files and databases, and that getting this information is just a matter of touching a few things on a computer keyboard and you get it spat out. No, in some cases, you're talking about, researching through, papers and archives, and it may actually be more complicated, which is why that conversation is so important. David?
I just want to shift gears a little bit. I want to ask Susanna, we have the rare opportunity of having a security expert. So a lot of us are freelancers. Is there a security virus thing we should be using not to get hacked? Is there a certain browser that's better than others? Just some practical tips.
Yeah, definitely. Running an antivirus is always a good idea. It catches a lot of problems before you download malicious software from websites. Keep in mind also when you're using email, most of the time it's not encrypted. You have to manually still today do a lot of your encryption. And so just standard email is done in plain text. So once it goes on the wire in the network, it's out there in plain text. And so, sophisticated people can read what's going on and read your emails. So, just be data conscious. You can use most of the browsers are pretty good. Keeping your operating system up to date is a good idea. Keeping the latest browser version up to date is considered good best practice. And also keep in mind that there's usually like a little locked icon when you're using the encryption level of data transmission, HTTPS. So you're using, TLS or SSL. So you are having some protection of encryption, and especially if you're using like a webmail client, you to the actual webmail is encrypted, but at that point, who knows what happens? So, that gives you kind of a false sense. You think that, hey, I'm using an encrypted session here, but yes, you too, a cloud service provider is encrypted, but what happens to your data? At that point, it's sort of, up to the cloud service provider. You can read their privacy policies. So it's a good idea to go through and read, keep up with privacy policies, and they change regularly. So again, data security is it's a continual effort. It's like growing an organic plant. You have to continually keep at it and watch it. And so keep in mind, again, security, the apps on your phone, you be wary what you install. Usually you should look for good, reputable apps out there. You can see their feedback. It's not 100%. Again, like I said, this is sort of risk. You can't guarantee that anything's highly perfect. But, if it has, nobody's really been complaining about privacy policies, or, make your own app is always a good idea. Make something that you trust and put it out there. Because then that it's behaving the way you want it to behave. And so you also shouldn't use browsers sometimes to store your passwords. It's considered best practice to have a different password for everything, especially, it's overwhelming. So, definitely the things that have high impact to you should have separate passwords, so that if somebody hacks into one of your sites, that they can't just go into all of your accounts. These are just sort of data safe measures that you can take. Again, unfortunately, nothing's perfect, but you can lower the probability that you're going to be exposed in some way.
Susanna, if we've got a confidential source who wants to get information to us, how should we have that interaction? How do we exchange information safely?
Yeah, well, that's a good question, like the de-identification. So it's very difficult to say perfect situation, because every company is different, every browser you're using is different, and the way they're being managed is different. So, just if you're trying to de-identify information, like you have to do that with medical records, there's a lot of things that you just hope that the software is going to actually you can actually buy software for de-identification of like medical records and things. But keep in mind, that it's a trust relationship that you have, and be mindful and wary of exactly, what you're trying to share, and if it is leaked, always consider the ramifications. That if you do lose confidentiality, what are these ramifications? You have to make kind of judgment calls. But yeah, unfortunately, there isn't a perfect way other than just kind of being mindful and remembering that email is not, encrypted by default. So there's a lot of room for error. You actually have to they usually use like a public key, private key system, so you actually have to negotiate in advance. Get like a public key, like GPG is the freeware. Pretty good. PGP is pretty good privacy. That used to be the one that's not paid for. It's open source. So you can use some of the open source tools to set up, a public key infrastructure for your emails and things. But then keep in mind, then you have to store your keys somewhere. It's very tricky. It's very difficult to do perfectly. And so, there's a lot of room, I think, for startups in this space, for business models that help enhance these kind, because it's a legitimate problems that are being asked, and people don't have the finances and financial, but as soon as you're trusting another party again, then you have to trust again. There's sort of the 3 pillars we talked about with the way they're managing and upkeeping. Yep.
If you trust your ISP, you might check with them because many ISPs do offer an encrypted level of security for email, but you've got to make your own decision as to whether that's practical. Ben,
Can I just
when you're...
ask one more question?
Certainly.
What do you think about Skype and other services like that? Is that secure? Or?
I mean, they're reasonable. I mean, they're considered, they're using best practices. But I mean, keep in mind, as soon as you're trusting another party, it's as much would you trust a driver to drive you somewhere? I mean, you have a lot of trust in other things, which they are following best practices. But again, there's a risk level there that you have to just be wary for when you start trusting that.
Yeah, and choosing your telecommunications mode is important. I am aware of some people that got into trouble. They were using Google Voice, which is a great service, but if you have it ring multiple phones, it's possible that that phone number is going to show up somewhere that you don't want it to show up. Ben, you've done a lot of source cultivation, and we've talked a lot about the nuances of FOIA, but the practical reality, we'll come back to you in just a second, sir. The practical reality of navigating sources and getting sources comfortable. Before you get the lawyers involved, what are some of the things that you can do as a journalist to bring those people to the point of being helpful?
Well, I wanted to say something about, I mean, the whole discussion here is about government and, suspecting government of not revealing public information. We obviously have a right to that, but there's a whole sort of other, parts of society which are also highly secretive, like corporations and non-profits even, and some of these sort of dodgy philanthropies even. And I think getting information out of these organisations is sometimes harder than a public one. And I think in those cases you can't go to the Constitution, you can't go to FOIA. You have to be able to cultivate the source itself, and I think. That can run the gamut from being so charming and buttering them up and telling them that they're wonderful to all the way to saying, if you don't tell me what's going on here, I'm going to get the story wrong, or you're not going to be able to put your side of the story, which I think is very catalytic often for getting people to talk, because once you tell people you're going to put something in the public eye, that they're sort of forced to say something.
Well, that's the fun part. If you've got some documents that reveal, the juice on somebody outside the government, and they're trying to stonewall you, and you call them back and say, hey, Dr. Smith, I've got this copy of a check that was written to you. Are you still saying you didn't get this? All of a sudden, the story might change. Yes, please.
I did have a security-related question. My name is Ed Tenner. I'm an independent writer. And I have used a service called SecureSafe, which is based in Switzerland, and they're a password manager, but they also have, for a few dollars a month, a subscription to a service that will let you securely upload documents and also transmit them to third parties, and you can actually text a key to those parties for accessing the documents. And nothing is completely secure, but I found this really to be very helpful when anybody asks me for a document, for example, with a social security number. So again, there's always the risk when you have everything in this one basket in Switzerland. Everything looks so tidy and well managed there. Nothing's completely secure. But services like that, I think, can be if they follow best practices, and this company has all kinds of certifications, I think they can be one way to solve that problem. Do you have any comment on that?
It's a great idea if it's working. Yeah, you have to do an analysis. You can have somebody do a risk assessment or something on the transmission and everything. Yeah, it's a good idea.
Susanna, how secure is it if I were to give somebody FTP access to my own server so that they're not transmitting something direct over the, well, actually, they're still transmitting it over the internet that way, right? So that's no good.
Yeah, exactly. And then who knows
That's
what they
the
do with
problem.
the passwords. You shouldn't have anonymous FTP sessions anymore. And, it's up, now you're trusting. It's always, security is very much a trust model. So then you're trusting them with the passwords. And so, yeah, it's very hard to manage these systems regularly, very much like trusting your house to somebody, and you're going to lend them your keys to your house. They're the same models that we've been having issues with for, a long time, but now we're dealing with this in cyberspace.
Matt, what's the liability for a journalist whose information slips out when they've promised somebody they won't let it slip?
So I have never seen a case where an accidental disclosure of a confidential source has resulted in liability. There's certainly liability by not disclosing your sources. We have something called the reporter's privilege. There's a federal reporter's privilege that's based in the Constitution that varies from jurisdiction to jurisdiction. So if you're in Virginia, it's going to be a tough haul. If you're in New York, probably going to feel pretty good about it. There's also shield laws in various states as well. That
But
protect
not every state.
But not every state. Certainly the vast majority of the states. And they all kind of vary, but generally what you're going to look at is if someone wants to get your confidential information by using the court's power to do so, they're going to have to show that the information that you hold is critical or necessary to their litigation and that they can't get that information elsewhere. Kind of more specific to the question, there has been liability for journalists who intentionally disclose confidential sources. There's a Supreme Court case from several decades ago where a journalist or a newspaper decided that the confidential source itself, the identity of the confidential source itself, was more newsworthy than the information that the confidential source gave to them and disclosed it. And the Supreme Court said that you don't get to use the First Amendment in such a case. And obviously, like, no one would volitionally burn a source like that, hopefully, but there is, if it's intentional, some potential liability there.
What about some of the things we've been seeing more recently where journalists crossing the border are being asked to share passwords or reveal information on their phones or whatever their device they're carrying?
Yeah, so that's actually a new and concerning issue. It didn't really come up that often. There have been a few cases throughout the years on it, nothing that really led to anything. But searches of journalists' devices has become, whether at the border or elsewhere, has become more and more frequent. The Reporters Committee for the Freedom of the Press, which is an excellent organization that has a lot of source material on all the things we've been talking about today, they keep track of these things, and I checked this morning, and there were 12 searches or destruction of journalist devices recently, which is not a few number, and certainly it's not a few number if you're one of the 12. Unfortunately, when you're crossing the border, I think there are arguments to be made as to the invasiveness of searches, especially with journalists, and certainly the CPB, even their regulations have some protections. It's unclear how far they would go, have some protections for journalists. But really, as far as if you think let's say you're gathering news abroad and you're holding sensitive information and you're concerned bringing it across the border, encryption has become a little easier recently than it used to be. It's very easy to encrypt your cell phone. It's relatively easy to encrypt your laptop. You turn these devices off when you go across the border. That's really like best practices, I think. Another best practice I think that people just don't really think of, and this happens to dovetail into the legal part of it too, is the iTouch thing, the thumbprint on your phone. Most courts are willing to compel, whether it be journalists or anyone else, to put their thumb on a phone to unlock it, but they're not willing to compel people to tell what their code is to get into the phone, because one's communicative, not to get into it, but one's communicative and one's just like a fingerprint. You get fingerprinted if you get arrested. That's just how things are. And so, like, really, it's kind of thinking about all of those things that you don't necessarily think about all the time, like, oh, I'm going across the border, I might have fewer rights. I should make sure my information is encrypted, and I should make sure that I'm not using, facial recognition to unlock your cell phone or thumbprint to unlock your cell phone, those things that aren't communicative.
Yes, but
If you do get stopped at the border and coming from Canada or Mexico or wherever, what should you do?
I think best practices are, first of all, know know what you're going to say. If you have very sensitive information like a confidential source, you should know going into it, this is going to be my line when push comes to shove. It really depends also on what position you are in. So if you're an American citizen, odds are you might get stopped. You might be held for several hours, but you'll eventually get into the country. If you're not an American citizen, there's certainly nothing requiring the government to let you in. And if you refuse to give over that information, it might prevent your entry into the country. But really, I think it's just reinforcing to whoever it might be that I have what I call a reporter's privilege that's vested in the Constitution. I've promised to keep this information secret. I can't disclose it to you. Just like I'm not saying that that is your line, but like have a line. And if that's going to be what you decide is ultimately worth, spending hours in a room for, then like that's the decision everybody makes. But as far as best practices go, it's definitely just knowing in advance what you're going to do in that moment, because those can be stressful moments. So it's helpful to have that.
Ben, can you talk a little bit about the kinds of stories that you're typically doing and how this balance between public and private information comes into play, and how do you get that information from whoever's holding it?
Could you be a bit more specific?
Sure. We've talked a lot about getting government information, but that's not the only source of good information. There's lots of great stories, as you've done. How do you use the knowledge that public records exist for some of what you're looking for, but you really want more than that? How do you find the sources and nurture them and give them the confidence to work with you, knowing that they are putting themselves in jeopardy? I mean, for example, has anybody ever had the accounting department of a private organization as a source? Has anybody tried?
I have an example. I was reporting on workplace safety, and I realized that there are a lot of engineers at that time working for the government who are really committed to saving people's lives, to saving injuries of workers, and I mean they're willing to get fired for that. So they would tell me things that other people wouldn't tell me. I remember I was interviewing one guy on electrical fatalities in California, and there was a whole series of workplace safety studies that Kalash had done. And I said, this is a great series. Why did you stop producing them? And he said, on the record, Ronald Reagan. So that's the way I relate to these people. Their mission.
Well, and that's important. It's like figuring out how to get to those people. When you've got a story, because you've got some evidence, but you don't have the whole thing, and you need more people to help, what are some of the ways that you can use that hard evidence you've got to get the rest of the information? I'm basically asking you to give your secret sauce for getting great stories.
Well, as I said before, I think everyone. I mean, you always have with a source that they sort of want to talk to you. Some part of them wants to kind of admit to whatever it is, or they want to just sort of open up. And I think that's sort of a natural advantage that you have as a journalist with human beings. When you call people up and you say, "What do you think about this? What about this?" There's sort of this natural inclination to want to respond, I think, often. So I think if you can cultivate people's sense of public responsibility, or their sense of just sort of their conversation, that they're wanting to actually tell you, then I think that's half the battle.
Charles, what do you do when you think you're going to be persuasive, but in fact you get the door slammed on you?
It's always tough. Ideally, when you're doing a documentary or data journalism, you will have enough evidence to go with a partial story, and you try to convince the source that it really is in their evidence to get, it is in their best interest to put their spin on what you think. And so if I have a little bit of data, I say, well, this is what it looks like to me. Please tell me that if I'm wrong. Please explain.
Exactly.
And it puts the burden upon them to try to steer it in another direction. So that's one way. Another kind of way of crowbarring information out is bluffing sometimes, which if you have partial information, you can make it look like you know more than you do. If you have a really good hunch that something is true, you can go to a source and say, well, when the FDA wrote you on such and such, and they told you this, what was your reaction? You might not have known that they told you something specific. You make it look like you know something, and they will discuss it, that specific point, thereby confirming something that you didn't know for sure. So you can kind of get little bits of information with an uncooperative source, but unless you really have a huge documentary breakthrough like that check, which was alluded to earlier, at most you're going to get bits and pieces.
That really happened, by the way. In a moment, I want to come to the issue of politics and how it affects the way we wrest information from our sources. But we have an audience question, a remote audience question.
Yeah, this was a question on Twitter a while back. I was trying to find a moment to break in over in the corner, and it wasn't working. So this is a specific question for Matt, but then I was going to add another broader question to tie it a little bit more into what we're on at this point. So the question is coming from @SFDoug, a question from Matthew. If a BuzzFeed freelancer has to pay for FOIA, do you reimburse on top of that? Because as freelancers, it gets really expensive. And my more broad question on that is, for the entire panel, how do you recommend freelancers approach investigative stories like this and approach FOIA? Because I'm a freelance reporter. We don't necessarily have the institutional support to do those kinds of stories. So do you have any tips for us freelancers?
Well, setting aside the specific question as to BuzzFeed, I will just have to leave him hanging for that one. But as to the substance of the more general question, FOIA is, up until the moment you decide to spend $400 and file a lawsuit, is a relatively cost-effective way to go about getting documents. Not only is it not that time intensive, because of the fee waivers I mentioned earlier, you can really do it for a pretty low cost. In addition to that, I would say we've been spending a lot of time talking about FOIA specifically, but there are also, especially I think probably with various science and technology fields, there's a lot of information that you can get for very low cost as well from states. Each state, maybe not all of them, but certainly the vast majority of them, have their kind of own version of like their little baby FOIAs. New York gets the Freedom of Information law, and Pennsylvania it's the Right to Know law. There are all these iterations of FOIA from state to state. So let's say a federal agency is giving you a headache with your request. You could say, well, shoot, I want this contract between this federal agency and this private party. I know they also did a deal in Florida, which has a very good public access law. I'm going to submit a request for the contract, which will probably be a form contract anyway, and get it from Florida since they aren't giving it to me through FOIA. So diversify, and also remember, again, always assert that you're doing this in the public interest and that you are a representative of the news media and you're seeking a fee waiver.
Ben or Charlie, anything?
Sure. I completely agree. A good tip if you want to get things faster is looking at some of the certain states are good, certain states are bad when it comes to FOIA. So it's like California is excellent. I'm California Public Records Act. I guess I wouldn't call myself a copperphile, but it's I like it.
Well, and actually, one thing that distinguishes the California law, I think, from every other state is that the California law is actually in the state constitution.
Mm-hmm. So, but unfortunately, under most circumstances, unless you have a very compelling reason for an expedited processing, or if you're going to one of these agencies that doesn't get a lot of requests, you have to budget in multiple months, possibly years, before getting these records back. So as a freelancer, my suggestion is to have a portfolio of these things. Just keep putting them in, and whenever something is of interest that's in your wheelhouse, you throw it in. Like actually in my wheelhouse, the EPA reaction to the AP story is of great interest to me. So I put in a FOIA yesterday. It's going to take a while. So you have these things brewing, and every so often you'll get an envelope in the mail, and it's like Christmas. It's actually more emails, fewer envelopes, but
They're still fun.
they're still. It's always a great day when you get a FOIA back and you're going through it and you're like, oh my god. My suggestion is just keep throwing them in. I highly suggest, and this is where the expense comes in, if you have problems, I think you should fight. And fighting means either appealing or there's another track with the OGIS, but eventually potentially suing. And even suing isn't that hard. It's surprisingly easy. There are lots of lawyers who will take a good FOIA case on spec because there is a provision within FOIA saying that you can get your money back if you substantially prevail. And so the lawyers will do that on contingency. And even pro se, if you go in, file a complaint on your own, it costs $400 to go to district court and do it. And I've done it a couple of times. If you want to learn about FOIA, the best way to do it is to litigate. Yes, I mean, there can be expenses, it can be difficult, but most of the time it doesn't cost you anything. And even when it does, most likely you're going to get your money back if you have a decent case.
Yes.
Yeah. Is there do you have to have certain standing to do these state FOIAs? Is there a better state to live in as a freelancer?
It depends on the information you're trying to get.
So, it just totally depends. Some states, although it's the minority of states, they have a citizen clause, or it's just drafted in the language of a citizen has right to public records. That is how Virginia does it.
Right.
That was taken to the Supreme Court maybe in 2014, and the Supreme Court said Virginia is completely welcome to limit its public records law to citizens of the Commonwealth. But other states, it's just people have a right to these records, and there, obviously, anyone can submit a request.
You have to be a citizen of the state you're living in to request it?
Yeah, and actually,
in certain states.
Of certain states, and actually, Muck Rock was mentioned earlier. I think they are putting together essentially a network of straw requesters. So if a journalist wants to request a record from Virginia, there will be a go-to in Virginia who can submit the request either in tandem with or on behalf of the journalist.
I love that. For any of you, what are some things that we should be thinking about besides FOIA to get that information? Because sometimes I think if you mention FOIA, all of a sudden that puts the request into a special category, when sometimes if you just say, hey, can you give me the information on such and such? Oh, here it is. How do you make that judgment?
Well, I mean, if you are a beat reporter and you're covering an agency which is subject to FOIA, you'll get to know the other outlets of information, and you'll get to know the people who are working there. And human sources are better than FOIA sources for the vast majority of what you want to do. They'll answer your calls. They'll speak to you. You're not going to wait 3 months for them to get back to you at a minimum. There are public meetings. I mean, going to advisory council meetings for federal agencies is incredibly valuable. You sit there, you hear what people are talking about, hear what people are concerned about. You make human contacts there. It may be giving you grist for some other action like FOIA, but I think that FOIA is, again, just one tool in your toolbox, and not everything is a nail. So try to use the other tools as well. And FOIA is slow, so it is not generally useful for most news reporting. It's really long features and investigative stuff that FOIA is useful for.
Ben, have you noticed that American sources have changed in their attitude toward you in the past year or two?
I mean, government sources?
Or any. You know, how has the climate about the media altered your work? I mean, obviously we've got the White House that hates us, but how has that trickled down to the rest of the work that we're trying to do?
Well, I mean, I think there's an environment now where journalists are not respected in the same way that they used to be. I mean, there used to be a sort of hierarchy of information that you had sort of government agencies at the top, or Harvard at the top, and then there were kind of media checking their information, and then there was kind of the public, and now everyone has an opinion, and everyone's voice is sort of equal in this rather garbled democracy that we have. So I think that makes things much more complicated. I think there's.
How have you had to change your tactics when you're doing science stories based on that? Or do you just stay?
Well, I don't, because I still go to, I still read the peer-reviewed journal article, and I write from that, because that's trustable because it's gone through an extensive process.
It does help, although even the peer review process has its own issues, which is, that's also where conflict of interest comes in, and again, the documents really do help.
So I feel I have to mention something. Though I absolutely agree that Trump is awful and a dedicated enemy of the press. He's made it very clear. It is not just due to him that the trend of lowering access is he's not the sole responsibility. In fact, the Obama administration, despite on the first day of office, he signed a memo talking about transparency and suggesting even changing some of the ground rules for FOIA and welcoming transparency. Actually, transparency in the Obama administration went down. I'm actually suing State Department for some documents now, and in the process of doing my case, I did some research. At the beginning of the Obama administration, about 20% of briefings were done on background, so press briefings were on background. By 2014, which is when I put my FOIA request in, that number had climbed to 90%. So there is a darkening of the window, and we're looking more and more through a glass darkly.
Well, that's a really good point, and it's also, it didn't turn on a dime when Obama became president, but certainly, it's not been real good for a while. And again, this is where understanding the laws are important. Yes, please.
Just to add, Obama went after whistleblowers fiercely, pretty much worse than anyone prior.
That's absolutely right. The Obama administration went after whistleblowers in ways that we'd never seen before, and that makes it much harder to cultivate those confidential sources that we so desperately need. We have just a couple of minutes left. I want to ask each of the panelists, what are a couple of specific things that we as working journalists should be thinking about as we're trying to get more information out to the public in a practical way without getting bogged down into years of litigation? Sort of like your top tips for.
Yeah. So in part, I would just reiterate what I said earlier, which is try to be relatively narrow with your FOIA requests. I think another thing is FOIA really lives in the footnotes. There are a lot of government reports with a lot of additional reports mentioned in footnotes. And if you see a footnote with a report and you can't get access to it, submit a FOIA request for it. It's super easy. There's websites like Muckrock, Reporters Committee. They've got forms to submit FOIA requests. Everyone submit one today. And then third, I would say, and this is a little bit more towards the litigation, but I do want to highlight, I think secrecy is not only increasing in the executive branch, it's also increasing in the judicial branch. There are a lot of disputes, a lot of litigation in the judicial branch, especially among companies and nonprofits that I'm sure many of you cover on a pretty regular basis, where records are sealed. I am a First Amendment lawyer at heart, and it really offends me that so many judicial records, which are also the public's business, are sealed. Again, This is something that pro bono lawyers do a lot. They will file motions to unseal records for you at the state level. Costs $45 if you went downtown and said, I want these records. And it's actually, if the lawyer's doing it pro bono, it doesn't cost anything to file a motion in federal court. So those would be my three.
I think there's nothing like a human source. There's nothing like knowing someone and talking to them face to face. I think as journalists and generally as citizens, we spend all our time on the phone, in the office, kind of hunkered down. And I think it's amazing when you go and see someone in a meeting or you meet someone for a drink or something. That's so much better always than even in a FOIA request.
Let's see, the practical advice. Well, first, I'll reiterate the fact that I think FOIA's power rests upon the fact that there are people willing to litigate and fight. So don't be afraid to do it, and it's not that hard. I think you're doing a service for everyone when you fight an unjust withholding. So that's one thing. I guess from another practical point of view, just a practical bit of advice. Since we journalists are also kind of balancing the problem of radical transparency while keeping stuff confidential, we have to be very cautious ourselves. And I guess the one top tip that I've seen reporters screw up again and again is watch your metadata. So every document contains, potentially contains information on who created it, when it was created, who passed it back and forth. There are lots and lots and lots and lots of fingerprints on the information you get, including information from confidential sources. I've seen a journalist at Politico looking for a verification of a document, hands it to a source, to the person the email purportedly comes from. The metadata was there, so they knew whom the person got the email from. Wound up in court. I wound up involved in a peripheral way. It was a nightmare for all involved. If you look up how John McAfee was caught in Guatemala, it all had to do with the fact that Vice didn't scrub the EXIF data from a photograph, and it had longitude and latitude of where the fugitive was. Be careful. Digital information and digital security is really difficult, and it is, unless you're kind of air-gapped and cowered in a fetal position in the corner, you're never completely secure.
Susanna, keep us safe.
Yeah, it's definitely, as we were saying earlier, do the background research on everything, the tools that you're using, the privacy policies, and also with the being proactive. So make sure to be proactive. Don't wait to read it somewhere else. As far as security, you can go on any search engine and look for best practices. I mean, be proactive on that. Maybe even get a group together to kind of keep, talk things over like we're doing here today for security reasons, and keep up to date. So be proactive, do the research, and keep up to date, I would say.
And I hope that everybody leaves here. If you're not going to file a FOIA, at least think about what public information should be out in the public that isn't, and how can you help wrest that free. Thank you all very much. This has been informative.